Hi, my name is Goldman. I'm the Director and Founder of Goldman & Associates. Our firm has a primary focus on family law issues. Please subscribe to our channel. Today we're going to talk about prenuptial agreements and the pros and cons. Well, I would say that the pros are something that are kind of well known. The idea of a prenuptial agreement is to preserve separate property, so that when a person gets married, if they had certain property already, that shouldn't be at risk should their marriage later fall apart and there later be a divorce. That's the goal of it, to protect the property, to protect the separate property, and sometimes even to protect the growth of that property. So that if a person, let's say, got married and they already have a home, that home should not be up for grabs during the divorce. And I guess that's the pros of getting it. You establish that right off the bat. Everybody knows both parts, very transparent on the assets, and that's a good thing. Here are the cons associated with that. Number one, sometimes when there's a discussion about signing a prenuptial agreement, that can cause disharmony within the relationship. People can say, you're already anticipating that the relationship will fail. That doesn't portend well for the marriage, these kind of things. To that I say, people write wills too. It doesn't mean they're going to die tomorrow. It just means that they want to make sure that in the unlikely event that something untoward should happen, there should be provisions for it. And that is really what the prenuptial agreement is like. You have to understand one thing though, and I regard this as a con. One of the cons of the prenuptial is that people think that the prenuptial agreement has the same force as the prenuptial agreement they saw about in Hollywood in the movies. They watch Bonfire of the Vanities. They think there's some sort of ironclad prenuptial that protects things, and maybe in some jurisdictions there might be that very thing. But in Michigan, prenuptial agreements are not that ironclad. And what I mean is, you can say whatever you want. Parties can agree on whatever they want, but in Michigan, ultimately, the judge gets to decide whether or not a fair settlement might involve invading the subject of the prenuptial agreement. In other words, the court will take every measure to honor the prenuptial agreement so long as it believes that the agreement is equitable and that the result will be an equitable result based on all things. However, if the court feels that the enforcement of the prenuptial agreement as it is written would visit a lack of an inequity, I should say, would visit an inequity on the marital dissolution and the division of assets, the court is free to dishonor all or part or some of that prenuptial agreement. I think that's a con, because I think a lot of people, when they're talking about pros and cons, don't realize that the thing's not ironclad. And a lot of clients will tell us, what do you mean? I have a contract. It's prenuptial agreement's a contract. Yeah, it is a contract, but there are overwhelming and there are superseding conditions of equity that the court deals with in determining what's appropriate in the dissolution of a marriage and a property distribution. If you have any questions about your case, reach out and we'll be glad to help you out.